Good afternoon, dear colleagues. On the 17th of August 2023 at 2 p.m. in the afternoon, it's my pleasure to introduce Mrs. Aurélie Caulier to you, who is Head of Public Affairs Europe of Zalando. I'm very, very happy to have her with us today because the topic we are talking about is really of utmost interest to everyone who is either into e-commerce or into digital law or into both, because we will be talking about this article more in detail. This is Article 33 of the Digital Services Act, which is one of the more recent acts of the European Union dealing with platforms and platform regulation. And Article 33 brings a definition on so-called very large online platforms. And very large online platforms face a lot, trust me, a lot of additional regulatory requirements that they need to meet in comparison with regular online platforms. And one of the outcomes, or one of the situations that we see at the moment is that the Commission has come up with a first list of very large online platforms. You can find that easily on the internet. Most of those are non-European. One of them is Zalando, and that's the reason why Aurélie is here with us today, because Zalando, interestingly, is claiming that this statement of the Commission that they were a very large online platform was false. And we will see now what's going to happen. This will certainly, or most certainly, or almost certainly will end with a decision of the Court of Justice of the European Union. We are in a very early stage of the development, so everything is still moving. I'm very interested to hear a little bit more about the background and about the details of this case. So Aurélie, thank you so much for coming. Let us perhaps start with the simplest question, which is, what is your personal story of the Digital Services Act so far? And where do we stand from your perspective at the moment?
Thank you very much, Nikolaos. Thank you for the invitation to Zalando, and I'm actually very happy to be here today. My personal story with the DSA was that about 5 years ago, Zalando built its EU Public Affairs team, and we already knew at the time that the e-commerce directive from 2000 would be revised. And I was very, very interested to work on that topic from a policy perspective, and to work, if possible, for a European company with a responsible business model. So this quickly led me to Zalando. And I started with Zalando 4 years ago. I'm a political scientist by training, so not a lawyer, but of course, when you do policy work or public affairs, as we say, you actually look very much at the details of the text, and that's actually what's really interesting. So this is my background. I think it's fair to say I've been working throughout these past years on the DSA, or the revision of the e-commerce directive, as it was known right at the beginning. So the text is well known, and actually now that it's adopted, final published in the UOG, the implementation is ongoing. So this is what we're going to discuss.
Yeah, so actually, I think when you started to work with this and on this, you would not have expected, I assume, that you would not have expected that after finally the decision was made, how the final text would look like, that you would end up so quickly again in a rather interesting and challenging debate on some of the details of the DSA. And I must also confess that as an academic trying to keep an overview about what's going on with the DSA, I would not have expected that something like Zalando is really in focus of this definition of a very large online platform. Let me just, for those of you who are not familiar with the text, briefly repeat that in principle, the definition in Article 33 says that if you are a platform having equal or higher than 45 million users as an average of monthly active recipients. So if you are above this number, then in principle you are you are a very large online platform, but according to Section 4 of Article 33, it is the Commission who has to finally take the decision on this after having consulted the member state of establishment. So when reading this, of course, everyone, or at least everyone I know, was thinking about the usual suspects here, which are Meta, Google, YouTube, etc., but not necessarily a company like Zalando. So my question to you, Aurélie, would be, was this to be expected? So did you know this already during the policy work before that was decided? And if yes, how did you prepare? If no, how did it happen and what happened then?
Yeah, maybe if we go back a little bit in time, for listeners, the category of a very large online platform is entirely new in EU law. So it didn't exist in the e-commerce directive. It doesn't exist in other EU legislations yet. So it's really created by the DSA, and the political rationale was to create special obligations for special platforms. And if the title of Section 5 of the DSA, which are the obligations for VLOP, this title says very clearly online platforms which have to manage systemic risk. So this vocabulary already gives you an indication as to the type of actors that the EU legislator wanted to target. And indeed, everyone had in mind the big social networks, the search engines, the large video sharing platforms. So platforms which share user-generated content and create debates in our European society. However, of course, the devil is always in the detail of the legal text. And the Article 33, which you were showing, which goes together with Article 24, paragraph 2, this category of very large online platform relies on one metric and one new concept. So the metric is 45 million. The concept is 45 million monthly active recipients of the service. So it's a new term. It's a new concept. The tech industry rather uses active users. So, and with this concept, in English, active recipients of the service, by the way, for Germanophones, the translation actually says Nutzer, so rather user again, so small trick here. But I'll use the English word. And this concept, the rationale in the Commission proposal was that 45 million corresponds to 10% of the EU population. So you could say 10% per month is a pretty big reach. But it's now down to how do you define an active recipient of the service? This point is not well defined in the DSA. And the DSA is a long text. It was negotiated very fast. So maybe for the history, the proposal came out, I think, in December 2020. And the adoption was in spring, or let's say the end of the trilogues, the end of the negotiation was in spring 2022, which, if you're familiar with EU law, 14, 15 months is a record time to negotiate such a fundamental piece of EU regulation. So the institution really wanted to go fast and tackle, let's say, some of the big challenges we know today from online platforms, be it illegal content, illegal products, harmful videos, etc. So there was a strong political willingness, and we supported the text from the beginning, by the way, as Zalando, because when applied to the e-commerce sector and outside of the VLOP obligations, there's a lot more obligations that will really change something for consumers. So here I'm speaking here also as a consumer of some online e-commerce platforms, Zalando and others, but the DSA will bring more checks. So for example, all e-commerce platforms or marketplaces will have to check their business users more strictly. So obviously, this leads to actually more legitimate business users, more responsible business sellers, and less illegal product or less counterfeit. So this is extremely positive. And we should not forget that in in the comments that I will make more specifically on VLOP, because the text is broader. So you mentioned it in introduction. 19 companies were designated by the European Commission as very large online platform. And so these 19 companies, Zalando included, have to implement the DSA earlier. So it was also a decision by the EU legislators to require these companies to make changes, these positive changes, earlier. So it's quite a challenge. let's be honest. But we have done the work. We've prepared early. So this is well ongoing, and the deadline is Friday, the 25th of August. So for these 19 companies, where you find Facebook, Twitter, TikTok, LinkedIn, a lot of companies, you and I, as European citizens, will see these changes fast. So it's also quite positive. Then down to the VLOP, this specific new category, which is raising a lot of questions. As I said, it hinges on one metric and one concept. And the concept of an active recipient is unfortunately not well defined in the DSA text. And there is a recital 77, which is also very unclear. So what happened among the European tech industry and beyond, what happened is that when we were required to publish these figures earlier this year, in February, there was a lot of discussion on what does it mean, where to publish, what is the basis, the technical basis and the technical standards behind the calculation of this number. So and this is whether you're large or small, you were under an obligation to provide information on how many active recipients of the service you have per month. So this led to quite a lot of discussion, and ultimately what happened is that when this information needed to be published or shared with the European Commission, companies took the definition that they thought was appropriate. So, and there were many different publications. Some companies decided not to publish their number. So it was a little bit of an incoherent way to proceed. And ultimately, it also leads to the absence of an equal basis to compare the numbers that were published by companies. So it's a key point for Zalando. It's not the only one. There's many others. But this point is relevant for the entire tech industry, because the requirement to provide this information was applying to everyone.
Yeah. May I just ask a little bit more about how one can expect this to happen? I mean, you have your numbers and all the others have their numbers. And as you mentioned, everyone was doing this in the way they thought that it would be appropriate. And then you sent this to the Commission and they are starting to calculate, and then they come back and forth, and then finally somebody sets a figure, and that's the outcome. Is it really going like this? So
pretty much.
Yeah.
So
okay. So it's like in a bargaining process somewhere, but nobody knows what the others are doing, or
there was no clarity. So the absence of a definition of what is an active recipient of the service meant companies did what they thought was best, with good intentions or other intentions. So the Commission, of course, had a lot of work earlier in spring to check this, but also the European Commission had maybe a little time at its disposal. and maybe not a full picture, because there is no standard in the tech industry, not a full picture of how the various companies have calculated down to technical level. So it's, I mean, we think as Zalando that this is an important work that needs to happen, because this is a key figure of the DSA, whether today or later, by the way. Some companies may grow and become VLOP later. So we hope this work can happen. The Commission is entitled by the DSA to issue a delegated act, so it can issue secondary legislation on this point. So we really hope it will do so. And like this, we would have comparable numbers, and companies would be designated on a basis which is the same.
Yeah, but at the moment, I mean, for the time being, just let me comment as a lawyer here. Reading recital 77 is technically and legally very, very challenging, I would say, because it's full of technical terms which are very open to interpretation, at least in my reading. And also then the translation of the technical interpretation into the legal meaning of it, meaning is somebody to be counted or not, is very challenging, I think. And if I then take into consideration that all the companies have different interests in this, first they have different technical environments, they have different technical protocols and standards and so on, and probably also different ways of counting internally. And then, of course, they also have different strategic interests in where they want to end up in this calculation, which would mean that at the very end, it looks rather, I would even say, random to me than what the final number is. But at least I don't see, as an outsider, how that finally happened or what finally came out of this. And I would assume that this is probably also true for all the other companies, with the exception of their own figures. So it's a kind of very bizarre game theory game, right? That everyone is playing here, I would say, right? That's strange. I mean, this is per se already very interesting, and it would be very nice to know a little bit more about the background figures and calculations, which are, as far as I know, not available to the public, are they?
It depends on the choice of the company. So Zalando,
yeah, but I mean, as a principle, you don't find them, right? No. Okay.
It depends how you read the DSA. Again, not always clear. We read the DSA as requiring us to publish the figures that we have of monthly active recipients of the service. Other companies read it differently and didn't publish these figures. And back to your point, in any case, the technical details are of course not publicly available. So they may have been shared with the European Commission or discussed in trade associations, but this is ultimately every company chose its definition. And maybe as a reminder, in the tech industry, what is tracked usually is the active users or active customers in the case of e-commerce, and the level of engagement. So how many articles do you come back after first order, or if you're a social network, how many hours do you spend per day looking at your account? So these are the metrics which are usually tracked rather accurately because they are usually business relevant. But this very understanding of an active an active recipient of the service, is it a site visitor? Is it an account holder? Or is it a customer? This is also at very top fundamental level. This is also not so clear from the DSA. So loads of questions, which needs to be looked into, and in the legal challenge that we brought against our designation, against Zalando's designation as a very large online platform, in the meaning of the DSA, this is one of the points we make, and it's of relevance generally for any platform falling in the scope of the DSA. And maybe I should add for listeners, the scope of the DSA is also very precise. So you have to be an intermediary, and there are 3 categories of intermediaries, which everyone who has studied the e-commerce directive will be familiar with. So you have mere conduit. You can think of cloud, for example. You have caching, which is a little bit Google search in the old years, where you had a listing of entries, and a hosting service provider. So 3 categories of intermediaries, and that's the scope of the DSA. There is a very clear exclusion of any other activities. So, and for anyone familiar with the e-commerce directive, it's the same scope.
Yeah, and that's already strange. I mean, this is one of the things which I personally find rather astonishing. I'm old enough to remember the debate on the e-commerce directive more than 20 years ago. I was already in the business then, and already then it was rather unclear why those 3 categories were taken. And in particular, the caching category, in my view, was already strange in 1999 or so, and it's still strange in 2023. And what is really, astonishing in my view is that this most fundamental part hasn't changed at all, although everything on the internet has changed since then. I mean, the internet looks so very different in every detail since 1999 or 2000, when the e-commerce directive was finally published. Still, we stick to this rather interesting in the categorization in 2023. So strange. I mean, very good news for lawyers, because, as I said, it keeps so many things unclear that we can debate in interesting seminars. But very difficult situation, I think, for companies, and also for the Commission being in charge now of interpreting this. I understand your point. Yeah.
Yeah, absolutely. So you can see continuity with the e-commerce directive, which was really the pillar for the emergence of any online activity in the EU. So continuity is perhaps good in this sense, but for at least for the category that I know the best, so hosting service provider, this 3rd category of intermediary, this is a very, very large category. And I'm often asked, but who is a platform? Who isn't a platform? And the answer is always, are you a hosting service provider of third-party content? So if you are an e-shop and you sell your own product, you do retail, and you're not in the scope of the DSA. If you are a marketplace with business sellers from across Europe, selling across Europe, you will be a hosting service provider of third-party content, because this content is the products or the images of the seller. So it's this is the rationale. I think our listeners would be familiar with this, but it's true. Thankfully, there is quite a lot of case law on the e-commerce directive about the concept of, are you an active platform or you're a passive platform? And if you're active, do you actually edit the content? And in this case, you would become liable, and you're actually no longer a hosting service provider in the meaning of the DSA or the e-commerce directive. So there's for you students, maybe there is definitely a lot that will happen there in the legal community to define these terms, assess the case law, and if I move to the claim that Zalando filed in front of the European Court of Justice, this is also a point, and a very fundamental point that we explore in our claim. And in a way, this will be a very important and very relevant point of case law. So we are aware of this. I'm happy to expand, because here we reach a bit the specificities of Zalando. So.
Yeah, I would very much appreciate this. So perhaps let's talk a little bit more about Zalando and its business model. But before doing so, let me just comment on your comment about the case law. I think the problem with the case law is that also the case law is in many cases already rather outdated, technically speaking. So when you look into those decisions, some of them are from 2000 whatsoever, so 10, 15 years old. And even something like Lavichnik Piscek is already now several years old as one of the leading cases many people are aware of. And the business model of the targets, I mean, the main targets, and also the environment of the main targets, such as Meta or YouTube, have changed so significantly that even in their cases, I would have plenty of room for argumentation, I think, to find explanations in how far the decisions would need to be or would not need to be, depending on which position I would be advocating for, to be further elaborated. And I think when it comes to companies like yours, things are even more complicated. So to simply looking into the existing case law and then stating, okay, this or that is a hosting service provider will be difficult or in any case. Yeah. But let's look into what Zalando is doing, if you agree. So you kindly sent me a short presentation that I'm going to share now. Is that the right moment? Yes.
Yeah,
okay.
I think probably.
Okay.
So our listeners can, if you're not familiar with Zalando, as you can see from this first introduction slide, Zalando is about fashion, but fashion and beauty, actually. And we have two other pillars, which is tech. So Zalando is obviously a tech company, and convenience. And convenience is the term to say logistics. So you cannot do e-commerce in the most satisfying way that you can wish for your customers if you don't have a very strong logistic footprint. So Zalando has a very strong footprint of logistic sites across Europe. So, and I should probably say our headquarters are in Berlin. So Zalando is originally created in Berlin. Very quickly, we expanded to Austria and Switzerland, so the DACH region, as we say. And then little by little to other European countries. So Zalando is active in 25 European markets in Europe. So we are actually in the list of the 19 very large online platforms designated at the end of April. We are the only European company in the sense that we're not global. We operate in Europe only. So you could also say the smallest actor. But if we look at the numbers behind Zalando, so last year we had 55 million active customers. So it's the metric which is the most relevant in e-commerce, which is which customer bought on Zalando last year, so 2022, and we had 50 million. But it's over a year, not over months, as in the DSA. On Zalando, you will find 7,000 brands, so fashion, beauty, and lifestyle brands. And this already gives you an indication. Zalando works with brands or retailers which are authorized by brands, and brick and mortar stores, which are also authorized retailers of brands. So on Zalando, you only find branded, high quality, legitimate products from brands. And it's very relevant to our claim. So, and in terms of how much sales do we have, in e-commerce, the metric is GMV, so gross merchandise value. Last year, we had 14.8 billion of sales. E-commerce is a high volume business for smaller profits. So, but this gives you a sense of the size. And maybe down to the business model, what's behind Zalando. So I said fashion, tech, and convenience. And you find these three pillars in the services. So if you're a customer, you will go on our fashion store. This fashion store includes several elements. So Zalando will be a retailer in this fashion store. So 64% of our sales are actually Zalando acting as a retailer. We sell directly products of brands that we have in stock, and we sell it directly to customers. There is also what we call partner program and connected retail, which is a partner business where a brand or a store directly will sell to Zalando customers. So this is what you see here, partner program and connected retail. The other services, marketing services, fulfillment solutions, launch, which is the online off-season fashion stocks, and outlets, so shops that you find of Zalando in Germany. These are additional services. But what is relevant for the DSA is the fashion store, our retail activity, which is outside of the scope, and the partner business, so partner program and connected retail. So this is maybe before we go into the specifics of our legal claim, this is what is important and highly relevant for it.
Okay, wonderful. And now perhaps you mentioned it already, Aurélie, let's come to the figures. So could you perhaps tell us how the commission ended up in a figure which is above 45 million monthly active recipients, and how you ended up in a number below, and how that happened or can be explained?
Yeah.
And the second question following up then would be, why are you challenging this? So wouldn't it be cheaper to simply accept it and continue instead of now, standing in front of a probably several year-long legal debate with everyone looking at you, and everything coming on top of this? So also the reasoning behind this would also be of interest to me.
Yeah, happy to. For the history of how this came about, so I already mentioned that because the DSA is imprecise, there was a lot of uncertainty within the European tech community or other actors about how to define an active recipient of the service, how to count it and come up with a monthly average, and how to publish it. So how to make it public. So Zalando looked at its figures, and what is specific to Zalando is that if you're a customer, you will see products which can be sold by Zalando, so our retail activity, which is outside of the scope, but also products, the same image, could actually lead you, if you choose a specific size, which is only in stock by a partner, this could lead you to actually not buy from Zalando, but buy from a partner, from a brand or from a store. And this decision, so you see just one product, one image. Most of these images, by the way, are actually shot, so taken by Zalando. We have a very large studio building in Berlin. So it's actually content that we created. And only ultimately, right at the end of the process, you will choose a size, in most cases, and it will immediately tell you, okay, this is sold by Zalando, this is sold by a brand, and it will also tell you who ships, who will do the parcel for you. So this is an entire process where we actually cannot track at the start. You come onto Zalando, we cannot say your site visit will be for Zalando retail outside of the scope, or for Zalando maybe a brand ultimately. So to be transparent, we decided to publish two figures: the total number of site visits and the total number of site visits, which ultimately leads one of our customers to buy from a brand or from a store. So, and this was, one way to look at it. We also wanted to be transparent about what is retail, so outside of the scope, and what is partner business, which is what the DSA is looking at. So this is why we published two figures. It's in our legal imprint. So as companies may have chosen differently, we wanted to be also transparent, and it's available to any customer. So this was our way. But these two figures, one is rather big per month because it's all site visits for the two business models of Zalando. So that's for the total hybrid business model. And the lower number, around 30 million, is site visits that will ultimately buy from Zalando. So in one of the number, we are over the threshold of 45 million. In the other number, for our partner business, we are below the threshold. So it's about 80 million and then about 30 million. So this transparency that we provided, we thought would have led to a debate on how do you count. Also, we decided to count site visits, which is, you would say, the largest definition. But we saw that other companies published numbers related to account users. So again, here the discrepancy that we were discussing in the beginning. And so we published these figures, the commission looked at them and decided to designate us. And in reverse, this is why we were saying, actually, this is not correct in several aspects.
And could you comment perhaps a little bit more about in how far that has a negative impact now on your business model in comparison with competitors, for example, that are not on the list? And again, why this is important enough to really go the hard way and to challenge this in front of the court?
Yeah, indeed, this was your second question. So there's several aspects. When you're designated a VLOP, you're part of a group of companies that are global, very, very big, and which really create the societal debate that we have in Europe about the role or the impact of tech actors, tech platforms. And these VLOPs, these platforms are presumed to have systemic risk for society. So fundamental rights, electoral debates, etc. So you can already hear that Zalando doesn't really fit in there. We are proud of the success and we sell good fashion brands, good beauty brands, but we are not in any other way.
Yeah, may I just interrupt you very briefly on this, because you are very clear in that argument. And if you read the headline, as you mentioned, of Section 5, stating that it's about managing systemic risks, the whole section, I would assume that somebody reading this and then watching into a company like Zalando, with all due respect, how important it is that people get their fashion to their homes conveniently, I think it's rather evident that this is not a systemic risk if it doesn't work, or if it works differently or whatsoever. So what about this argument? I mean, it's the most brutal and most fundamental argument, I think, that one could make. Was that heard, or did that play any role, or do you think that it will play a role now? That would be, it's astonishing to me. Let's put it like this. Yeah.
It played a role in the political discussions when this new category of VLOP or VLOCs for search engine was created. It played a role. So the EU legislators wanted to have a risk approach and create more obligations for special platforms.
So it's a little bit like in GDPR, where everyone was talking about Facebook and Google already then in GDPR, and suddenly it turned out that this applies to everything, right? So it reminds me a little bit of that debate then.
You can draw indeed many parallels. These social media were also thought about when the category was created for the DSA. But if you look at the text, here come the fun, if you like, to deal with legal text. The category hinges on this metric, 45 million, and this concept, active recipients of the service. And that's it. And it's an automatic. You reach the threshold, you will be designated. So there is no process to discuss. So this qualitative concept of systemic risk is actually not found in the designation process.
Well, I could argue, or one could try to argue that if the method is unclear, leading to the 45 million, then and the calculation is unclear, then the purpose of all this needs to be put into the way how things are calculated, right? So it would, I mean, that's a rather classical legal argument, I would say, right? But of course, if you finally end up with a number that is above 45 million, then there's no more room of interpretation. But again, if the number per se is not clear, there's plenty of room for interpretation, leading to a rather restrictive way of calculating things, I would say.
Indeed. And you mentioned it, but this VLOP category implies an earlier deadline for implementation, so Friday the 25th of August, very soon. And it implies a lot of obligations. So, as a European citizens, I want to say it might be fair that the bigger platforms, the more risky platforms have more obligations. But in the case of Zalando, we have zero risk of illegal content. And this here, moving away from this general argument that we made on the calculation methods and going to Zalando specifically, or to any highly curated e-commerce business, if you don't have or if you don't host third-party content, so if you don't control or edit that content, you are clearly a hosting service provider of third-party content. So back to the definition of who is in the scope of the DSA. In the case of Zalando, we have very strict internal processes. And to give you a few examples, the business checks that we run on the business partners of Zalando are extremely extensive, and down to the content that they use. So what will the customer see? The pictures is most likely shot by us. The product is for 64% of our sales sold by Zalando, so it's our own. We're liable, and the product descriptions or the image are screened by Zalando. So in a way, we can really say we actually don't have this risk of illegal or harmful third-party content, not at all. So that's a key part of our legal claim. And here, it's really a matter for the courts to decide. So I would say it's a bit similar to some of the cases brought forward in the e-commerce directive to clarify the scope. Here, it's a new case in the DSA, which is if you don't have third-party content because you have controlled or screened that content, you are, as we say in the fashion sector, you are a highly curated business model, and it's very common actually in fashion, beauty, or electronics, among others. But and the reason is if you want to be a good business to your customers, and if you want them to come back, you have to sell legitimate products, or in other way, your products cannot be counterfeit. They have to be genuine. And this is the case for Zalando. We really sell products from brands, or branded products sold by retailers or brick and mortar stores. So it's really a safe, you would say, a safe online environment with high quality products from branded partners. So this is a point of the claim, which is in this case of Zalando, of a highly curated business. We argue we cannot be considered as providing or having a risk of illegal and harmful content. So, and this is a point to clarify. And if I may, it echoes what you were saying on the huge variety of business models online that have emerged in the last 20 years. This is one business model. It's very different from being a social network or a search engine or even a marketplace. So there's a variety of business model, and this is where we argue it's also a fundamental reason why Zalando should not have been designated.
Yeah. May I insist once again on the question, sorry, which is why not simply taking the decision despite of the fact that one doesn't agree with the commission and proceed instead of this challenging it in front of a court?
Yeah, simply, it's a competitive disadvantage. So, and out of principle, if you are designated the very large online platforms, you want to be designated for the right reasons and not for the wrong reasons. So maybe on the competitive disadvantage, we talked of the earlier implementation deadline, the large number of obligations. They are costly. So for example, there is a risk assessment to be made. There needs to be an external audit, an independent external audit every year, and so on and so forth. So it's quite a long list. And second, if you're designated for the wrong reasons, it's a further competitive disadvantage. And there's maybe a third point, which is important to mention. The VLOP category, so created specifically for the DSA, starts to be used in other pieces of EU legislation. So we see a leak of this very specific category into other text with additional obligations. So if you think towards the future, this is also way, additional burden, which if you carry these burdens, it has to be for the right reasons, for the right designation reason. This being said, so we're challenging the way Zalando was assessed. We think there were fundamental errors in our business model and also in this calculation methodology. Sorry, I lost my point. But in a way, this is quite fundamental, and we had to challenge, but we still have to comply.
This is one of the things that need to go into the calculation when deciding on whether or not to sue. Is that it doesn't change anything at the moment, right? You still have to comply. So it doesn't give you absolute freedom now for the case. On the contrary, I think everyone is more interested now in what exactly Zalando is doing, and you are very much on stage at the moment, I would assume. So it's probably not an easy decision to take. Let me ask whether you went out proactively. You also decided, by the way, not only on suing, but you also decided on actively communicating that you would sue. This is how I came across your case by simply reading it on the internet, which is another strategic decision to proactively, also come here and talk about it. Comes also with pros and cons. One of the cons is, again, if you lose, people will have that very much more on the radar than they would have if you would have done it silently. So my question is now, were there any reactions coming so far, be it from the commission, being from competitors, being from other people on the list that are worth being mentioned?
Yeah, it's true. So we decided to file a claim, which was a major decision. Of course, it's quite common. No? So the European Commission or EU legislation goes or is put in front of the European Court quite often. But for Zalando, it was a very important decision. We also decided to communicate and to explain what were the points, because we think these points are relevant also beyond Zalando. So we mentioned this very general point on how to calculate an active recipient of the service, which later becomes the basis for being a VLOP. This is relevant for any online platform in the DSA. Our second point is relevant for all hybrid platforms. So if you have a hybrid business model where you combine, for example, in e-commerce, you combine retail, so you sell your own product, and you combine a partner business or a platform business or marketplace. Our retail business was considered in the Commission assessment, while it's clearly outside of the scope of the DSA. So here there needs to be a clarification, a legal clarification, and there are actually quite a few business models which are hybrid. because you may start as a shop and then you grow because you want to attract more brands, you want to be more relevant to customers, and you start a marketplace. And this is a way to grow your business, which is very common in e-commerce. So it's relevant for here all actors that are thinking of having a marketplace. And then the specific point on Zalando, the fact that we're highly curated, this was really business relevant. It goes down to the way Zalando operates, and how we make sure we have no counterfeit and zero risk of illegal products. But it's also relevant for all the online companies that want to be this highly curated business. So it's also why we decided to communicate, because the DSA is a new text. All of these 3 points require to be looked into. So it was worth communicating about it.
Yeah. And any reactions so far from anyone relevant?
Yeah. What I heard a lot, among the public affairs policy community, was that European actors, so European tech actors, were actually rather happy to see that we were seeking a clarification on the calculation methodology. So this was welcome, that we were asking formally, in the most formal way possible, in front of the European Court, for these clarifications. So this was highly welcomed. And then for all other hybrid actors, there's also a big relevance here. So we also receive reactions on that. If you have a double business model like Zalando, how do you deal with counting these active recipients? This was welcome. Of course, we are aware that there has been a second legal challenge of a designation, so not of the DSA, but of a designation as a very large online platform, done by Amazon. And here, from the press, Amazon seemed to be rather pointing at this notion of systemic risk that we also explored, and which is in the title of the VLOP category, but not necessarily taken as an assessment criteria elsewhere.
Yeah, so I mean, as an academic and as a member of the public, one of the things that I would have appreciated would have been some kind of more transparency about the calculation method provided by the Commission. But so far, if I didn't miss anything, me as someone who is not into any of the cases, for me, it's rather difficult to assess that and to find that out. And I think this is one of the problems here, because obviously people like me need to also, or at least I hope that it's part of my job to contribute to the interpretation of the text. And if that is true, then I'm lacking, and people like me are lacking quite a lot of information here at the moment. So have you heard anything about a change of politics when it comes to transparency related to calculation in accordance with VLOPs or anything in that area?
Not specifically, but back to this possibility that the Commission is granted by the DSA to issue a delegated act. There is a condition to issue that delegated act, which is national authorities that will enforce the DSA for any platform which is not a VLOP. This gremium, we would say in German, this body of digital services coordinators, as they will be called, this body needs to be established. So there was a question of timing, because we're still in the very beginning of the implementation. There was a question of timing to respect, but what I hope is that this delegated act can actually provide these common standards, which will mean that you or anyone in the legal community, in the academic communities, could actually look at the results, compare the figures as well between the companies, compare the definitions, and we would all have a standard.
Yeah, I mean, for the time being, just let me add to this that it's a little bit bizarre that the only European company on the list which is already per se a problem in my view from a geostrategical point of view, that the European Union is producing a legal text and 18 out of 19 companies affected by it are outside European companies. So that the only one being European is already challenging this from the very beginning, right? So this is also, I mean, it's some irony in this, I would say, right? Because it, of course, I mean, if your argument is true, that it has a negative impact on business models like yours, then it's affecting European industry in the moment here, or at least one very important player of European industry in the domain, in a way that is not positive for Europe as an economical environment for everyone there. So, I mean, this is also something which, in my view, is unexpected that it would happen, right?
Yeah.
I don't think that a member of the parliament had this in mind when agreeing to the DSA.
No, of course, the intention was entirely different.
Yeah.
And as I said, we actually still support the text of the DSA because it does bring good fundamental changes, and consumers will see this very fast. So, either by the end of this month of August, or by February next year for all other companies. So this is actually positive. What we contest is really the designation, the fact that the specificities of Zalando's business model were not looked into, and the fact that the calculation methodology was not consistent, was lacking, which led to unequal treatment. And for sure, what you mentioned, the burden of being a VLOP is actually pretty big, and we argue disproportional to what Zalando is. So.
Yeah. Aurélie, may I come to an end by a very simple question once again, which is what's going to happen next? Do you have any indications to share about when you think that we will have a court decision, whether there will be anything in between, etc.? So about the timing.
Happy to share. The next, so in the immediate future, the deadline for implementation for these 19 VLOPs is Friday, 25th of August, so extremely soon, in a few days. Zalando is, complying with that deadline for the VLOP obligations and for the rest of the DSA. So it's really the entire DSA. We have filed our claim at the end of June. This claim was shared with the European Commission, from the European Court to the European Commission. The European Commission has about 2 months to answer. And then the court will decide whether the written submissions are enough or whether there might be a hearing. So we'll see what is decided. And ultimately, I would say this case is probably going to take, 18, 24 months. Let's see. You never know. But it will take a certain time. So it's from Zalando's perspective, we're not winning time. we're not winning any money. It was really a question of principle to seek the clarifications that we need.
Yeah. So then let's see what's going to happen in the next 18 to 24 months. Perhaps it's going to be earlier. Nobody ever knows. So we'll see. For the moment, Aurélie, I want to thank you most warmly for your time. I would already now very kindly invite you to follow up to this when we have the decision. If you agree, I would really appreciate to discuss it once again then with you. And for the moment, thank you so much for everything that you shared with us, and in particular for your time. And
thank you very much to you for the invitation. It was a pleasure.
Thank you. Thank you. And to all the people listening to this, thank you very much for your time. I hope that we stay connected. And in particular, I hope that you stay as healthy as possible or become as healthy as possible, as quickly as possible. All the best and take care. Bye-bye.
Bye-bye.